Thank you. All right, good morning, everyone. This is the appellate court conducting a Microsoft Teams hearing in the matter of Sims versus Zucco, which is docket number 44407. The first order of business is to have everyone identify themselves so that we can all be sure that everyone can hear and see each other. So we'll begin with the judges and then counsel, and then our self-represented party. God bless you. I'm Judge Prescott.
Good morning, Judge Clark.
Good morning, Judge DiPentima.
Good morning.
Go ahead.
Go ahead. I'm sorry. Good morning, Tracy Sims.
And Your Honor, I am the appellant, Attorney David DeRosa for Mr. Zucco.
Okay. All right. And it appears that everyone can see and hear each other. Just to briefly go over the rules for argument, each side will have 20 minutes for their presentation. Ms. Sims, because you, I'm sorry, you're the appellee, so you'll just have your 20 minutes. Attorney DeRosa will have a right to use a portion of his 20 minutes for rebuttal time, so he should let me know when he begins his argument. Because we're doing this online, we don't have a timing system, so I will try and let you know when you have about 2 minutes left in your argument.
Sure.
And the other important thing is just to kind of keep an eye on the judges. And, you know, I'll try and raise my hand, and my panelists will do the same if we want to interrupt you with a question, and just recognize that one of us has a question to ask, and we'll jump in and get it done that way. Any questions, Ms. Sims?
None right now.
Any questions, Attorney DeRosa?
No, Your Honor, I've done this before a year ago. Same argument. In fact, Your Honor was on a panel with me.
Yeah, Attorney DiPentima. We can't hear you.
You have to hear.
I just wanted to note that when we're not speaking, we're going to be muted, correct?
Yes.
Oh.
Yeah. Everyone try and mute so that we don't get background noise. That's very helpful. And when it's time for you to speak, you just turn your microphone back on.
Okay.
All right. With that, I think we're ready to go. Attorney DeRosa.
Good day, Your Honor. May it please the court. My name is Attorney David DeRosa, and I represent Augusto Zucco. Your Honor, may I reserve 2 minutes for rebuttal? May I begin? Okay. First issue on appeal is whether the service of process by the marshal comported with due process under the United States and the Connecticut Constitution, when it was otherwise legally insufficient under General Statutes 46B86. The court relied on a dismissal concept under 5252 and 5250 when it decided that the motion should be considered. What I'm referring to, Your Honors, you can find on page A55 of the decision. And I'd like to point the court to page let's see here. Beginning on page A45 is the motion for order of notice in a family case in which they sought to serve it by marshal, and they were allowed, the court permitted it to do it by return receipt requested. And my submission on page A49 by the very return of service, supplemental return of service, that the return receipt was undelivered into the letter address, was undelivered to Augusto Zucco, and it was signed on the next page and not delivered to him, and therefore they did not have proper service to seek retroactivity under 46B-86.
Okay.
Sure, Your Honor.
A couple questions about the service issue.
Sure.
First of all, you don't dispute, I take it, that that your client's daughter signed the green card.
It was, yeah, it's a stepdaughter, but I don't think it's his daughter, but I'm not disputing that. No.
Okay, someone living in the house.
I understand that that there's someone living in the house at the time, yes.
Okay, and I want to be clear about what your argument is. Are you claiming that even if Mr. Zucco had signed the card himself, that this would still be an improper manner of service?
There's two arguments. That's a backup argument. I'm making two arguments, Your Honor. First, I'm arguing he wasn't properly served, and I know that there might be an argument that it was a bowed service. The second argument I'm making is that under 5250 or 5252, the thing that I think the judge confuses below.
Attorney DeRosa, let me interrupt because I'm not clear about what your answer is. So what I understand you to be saying in part is that even if it was sent to him by certified mail, return receipt requested, and he had signed the green card, that would not be proper service. Am I right that you're making that argument?
I am making that argument in part, Your Honor. I mean, I'm one of alternatives. I just want to make sure that's clear. Sure, go ahead.
Let me ask you about that. If that's not a proper manner of service, how was Ms. Sims obligated to serve your client?
Your Honor,
what would be the proper manner of service?
you'd have to hire a substitute marshal or an indifferent person to serve the person physically in Pennsylvania. That's what I'd submit would be proper.
And where are you getting that from?
Well, Your Honor, I'm getting it from, 5250 says that it was supposed to be served by marshal, and basic due process requires that my client have actual knowledge or some, well, I wouldn't say actual knowledge, but has to have there has to be some indicia that, in fact, he did receive or was on notice of this proceeding below.
But a Connecticut marshal can't go to Pennsylvania and serve these papers.
I understand that, Your Honor.
Right?
Yeah.
So I'm not hearing from you a way that service would have been possible under the circumstances of this case, merely because your client was in Pennsylvania.
Well, I mean, they did seek substitute. You can seek substitute service, Your Honor, and they did so in this case. And they said it served it by green card, and then the judge signed off on it by green card at the time. But the marshal declared it was not delivered.
But you're arguing that even that is not a proper manner of service. And so my question is what is?
Well, if you sought to a proper manner of service under statute would be to seek, in accordance to the request, is to have service done by an authorized person in the state where the party is to be notified lives, or to make such other order or notice the court seems reasonable. I would think that a proper order of notice would be one by which, in a manner consistent with the manner a marshal would serve here in Connecticut, but in Pennsylvania, Your Honor, instead of by certified mail, that ensures that Mr. Zucco was on notice of the proceeding below. But what I'm concerned about, Your Honor, is that the judge, the big point I'm trying to make is the court says that since my client was time barred from challenging service, that he's confusing the dismissal of the motion on grounds of lack of service with the ability of the court under 46B-86 to find for retroactivity. I think that they're not the same, Your Honor. I do believe that the attorney below was obligated to establish under 46B-86 that there was proper service made in the case. And he can't say, well, they didn't move to dismiss it for improper service. Well, maybe you didn't move it for improper service, but you're asking for retroactivity for $2,000 a week to the tune of $110,000, which is what happened in this case. So they have an affirmative obligation to establish that service was proper, and I don't believe they did so in this case. And then I don't want to make a nuance here, Your Honor, but I want to be clear. I am saying that the marshal did say it was undelivered to that person at that location. Yes. Yes, sir.
You're not claiming a lack of actual notice, correct?
Your Honor, I mean, he did appear in the case, and he did at some point proceed. But I am saying that 46B-86 requires for retroactivity proper notice. Yes, Your Honor.
Let me try again. You're not claiming, are you, that your client lacked actual notice of the motion?
I'm not. I don't think I can do that, Your Honor.
Okay.
I'm submitting I can't do that. I mean, I'm not saying that he didn't have actual notice of the motion in question. I am submitting that it wasn't properly served for purpose of retroactivity.
I understand.
Okay. And that was largely my first argument. I know I have limited time here, so I'm going to move on to my next argument, which was about the bankruptcy stay. Now, I have to submit to the court, I've made an error in my appendix. There was a there was an app number 181 I rely on docket entry 181, and I did not include it in the appendix. So I'm asking the court, I can provide a copy to the court, or I just ask the court to look for it in the record, because I rely upon it in my argument. And in that affidavit of bankruptcy, Mr. Zucco asserts and provides the order of relief from the Pennsylvania Bankruptcy Court. And in the text of that order of relief from the 11 USC 362 bankruptcy stay, the court made very specific.
Attorney DeRosa, Judge Clark has a question.
Yes, Your Honor.
Counsel, did your client ever take any action in the bankruptcy court seeking an order that anyone, including Ms. Sims, had violated the automatic stay?
I don't believe so, Your Honor. Not that I'm aware of. He did not claim that they asked for relief from the automatic stay. I am sure there was a hearing on it. It was contested, and then the court issued what essentially is
No, Counselor. So
yes, Your Honor.
During the course of the proceedings below in this case, it became clear at some point what Ms. Sims was seeking by way of relief, correct?
Yes.
And then there was an order that you claim violated the stay, correct?
Yes, Your Honor.
And you never went back to the bankruptcy, your client never went back to the bankruptcy court and asked the bankruptcy court to find that anyone, including the court below, violated the bankruptcy court's order, right?
I don't believe that's what we did. Instead, he contacted me.
No. I want to know whether that is what happened.
Let me ask you, I don't normally ask questions of the court, but are you referring after the order in this case that's being?
Right. Either way, at any time, did your client go to the bankruptcy court and seek relief by way of an adversary proceeding, which is typically how these things are resolved, alleging that anyone, including the court or Ms. Sims, violated the automatic stay?
Your Honor, that has not happened. That has not happened. I don't believe my client. I'm not knowledgeable. I'll be honest, Your Honor. I'm a little bit at a disadvantage because I'm not completely knowledgeable. There's a gentleman in Pennsylvania named Imroff who's his lawyer for bankruptcy in Pennsylvania. I don't know all the ins and outs of what's going on in the bankruptcy record below, but to my knowledge, that did not happen.
So you want us to determine whether or not someone violated a provision of the bankruptcy code, right?
Well, I'm not actually, Your Honor. I'm more concerned. I think Your Honor knows what the bankruptcy code is. I think this court knows what it is. Well, I'm more concerned about the language of the order of relief from automatic stay by the judge in Pennsylvania.
Yeah, no, you're asking us to interpret that order and rule whether or not someone violated a federal court's order, right?
Well, I mean,
yes.
well, but Your Honor, if I may, the order in question is clear. The order says that you can only seek movement to all actions necessary to enforce any of the said order for domestic support obligations. But it says it's very clear that the automatic stay of 11 USC is not terminated as to any issue.
Counselor, I'm sorry. I've read the order. I know what it says.
Fair
I'm
enough.
trying to figure out which court ought to be adjudicating a violation of the automatic stay.
Well, I mean, I'm going to say, obviously, that I think both courts have jurisdiction in this particular circumstance because obviously this judge is subject to the oversight of this court and not necessarily. Yes, Your Honor.
Attorney DeRosa, did you raise this issue before the trial court?
This particular issue about the automatic stay? Your Honor, first of all, I didn't raise anything, but I'm
speaking of your client.
Yeah, I understand. You're saying the party below. I do not believe, Your Honor, that the automatic stay was addressed. You have to understand what happened, just by way of background. initially we won this motion, Your Honor. And then counsel was hired, Mr. Lewis. He won the motion. A re-argument was considered. The issue was the first issue, Your Honor, about whether service was made and proper service was made. And then suddenly this order came out that you see located at 855. And there was no.
But at any time, did your
Right.
client, through counsel or on his own, say to the trial court, you cannot proceed on Mrs. Sims' motion because of the automatic bankruptcy stay?
What I can, the answer is no, but the reason is because nobody knew what this order by the judge came out after very little litigation between, it was very one-sided in a sense. And when Mr. Lewis came back, Mr. Lewis was under the impression that the only issue before the court was whether service was going to be had or not, and that one would have a future hearing after if re-argument were to be granted. That, in fact, is not what happened. The judge just, yes, Your Honor.
I'm sorry, Judge Prescott, did you want to follow up?
No, I'm fine.
Okay, so Counselor, help me understand precisely what part of the order, in your view, violated the automatic stay?
The fact that I believe that the order to establish alimony is prospective in nature.
Right. So I understand. So wasn't it clear, though, prior to the court's order, that Ms. Sims was seeking retroactive alimony?
I do think that was clear, Your Honor.
And your client didn't raise at any time with the court that might violate another court's order, right?
But Your Honor, we never had the opportunity to raise that with the court because the court ruled in our favor, heard a re-argument motion, and then issued that two-page decision. We never, in other words, Your Honor, Mr. Lewis thought he was if the court was gonna grant re-argument, he would have an opportunity to present his evidence. It appeared that from the court's point of view, the date of re-argument, he had to have his person there ready to go with his evidence, because if the court was going to address that, evidence at that time. So what happened was they have the hearing and then the decision is issued. So my client never really had an opportunity to do what you're indicating. We never brought up that issue because we never knew that they were going to seek this retroactivity in question. And Your Honor, I mean, it wasn't even if Your Honor doesn't read the record the way I just said it, and it said a different way, it's just that my client didn't really have the opportunity to address the issue. And finally, I do believe that whether the bankruptcy court is supposed to have jurisdiction over this or Your Honors are supposed to, the court order is what it is. It has to be respected, and Your Honors are the court of error correction. And if this order was misread by the superior court, I don't think it's inappropriate to raise as a legal issue before this court. I don't think I'm precluded, or this court doesn't have jurisdiction over the matter. Thank you, Your Honor. Yes, Your Honor.
Well, what about we decided that they violated the automatic stay, and then Ms. Sims went to the bankruptcy court, and the bankruptcy court said that it didn't violate the automatic stay. Then what?
Well, I mean, if that were the case, that's a. I want to answer your question. I'm just trying to think of an appropriate answer. The bankruptcy court issues its own order, and if it, as the author of its order, it may have more prerogative as to what it intended. But at the same time, I mean, frankly, issues of federalism and the like, I think that I guess the bankruptcy court would in some sense be the court of last resort, but I don't think that it precludes this court from acting appropriately on this matter. That's the answer to my question. I guess I would say that I would probably be forced to say the bankruptcy court is the final adjudicator of its order. But it's not inappropriate for this court to opine on its order, just as it isn't because just as a superior court judge has to review this and basically interpret it, this court is in the same position as the superior court in interpreting the order. It's a pure question in some ways of law. It's not a discretionary question, Your Honor. And the other thing is that, I mean, there was a restriction here about establishing, modifying, and enforcing. And the establishment in our case, I believe is prospective. Your Honor, I don't know how much time do I have? I have 22 seconds. Your Honor, I'm going to reserve the balance of my time for rebuttal. I'll rely on the third argument on my brief. All I want to say about that is that I believe that alimony shouldn't have been ordered in this case, and that it was an abuse of discretion because my client's in bankruptcy and Ms. Sims is financially very stable, as indicated by her. That's time, as indicated by her affidavit. I'll reserve the balance of my time for rebuttal. Thank you.
Okay, Sims, you have 2 minutes for argument. And again, just if we have any questions, we'll try and raise our hand and please try and acknowledge us.
Okay, can everyone hear me?
Yes.
Well, first of all, I would like to say that on page 125 of my brief is a order from the bankruptcy judge, Henry Van Eyck, that he terminated the automatic stay on July 2nd of 2019. In order for me, because at that point, no one heard the trial yet. The trial began on October 8th, 2019. So obviously we didn't know what was going on, how the trial was going to end up. So that's why the judge terminated the automatic stay. Also on page 129 of my brief from my attorney, Tracy Updike, she explains everything of not only about the bankruptcy judges, how he came up with everything, but she also clarified what bankruptcy was all about and how to also have the money retroactive. There's one in bankruptcy code 101-14A defines domestic support, and that is owned to or recoverable by a spouse, former spouse, or child of the debtor, and the nature of alimony, maintenance, or support. So that does include alimony arrearages. I also want to point out that the defendant had 3 opportunities to attend the trial: October 8th of 2019 and November 10th, 2019, and on December 5th, 2019. The defendant had many excuses why he could not be there. On October 8th, 2019, the reason why he just couldn't show up, but he did call Judge Trulia and ask for a phone conference. Judge Trulia advised him that he would excuse him this one last time, and they do not do phone conferences, and then rescheduled for November 12th, 2019. I did attend. The defendant was not there. His excuse was his wife was sick. And then it was rescheduled for December 5th, 2019. The defendant asked for an extension because his grandfather-in-law died. His grandfather-in-law, actually, the funeral was the day before trial, and Judge Eshok denied it and still began, Judge Trulia went ahead and still heard it on the 5th. And then he did deny it, my motion. I put in for a re-argument on January 3rd. And then, I'm sorry, I'm trying to get my dates correct. January 13th, I did file the motion for reconsider, January 13th, 2020. And then on February 10th, that's when we were heard before. And the only motion what the defendant could come up with is he wasn't served properly. And again, I believe from page 2 to 22 and on 64 of my brief, the defendant was obviously hired the marshal. And, oh, yes.
At that January 10th hearing, was Mr. Zucco there?
I'm sorry, the January 13th, 2020?
January 13th, sorry.
No, he was not.
Okay.
And then I also want to bring to the fact that the defendant wants a motion for modification. I was never properly served. I was never served by marshal, nor a certified letter. I received a letter from the Danbury Courthouse to be in court on November 4th of 2021, and I did attend court. But I was not served by a marshal, and I did not receive a certified letter. Yes.
Ms. Sims, when is the last time that Mr. Zucco, to your knowledge, filed a financial affidavit in this case?
In this case, he's never filed a financial affidavit ever.
Even at trial, the original dissolution trial?
Oh, in 2014, he did file that one.
Okay, since then, has he filed a financial affidavit at any time?
No. I think that's all I have. I'm new at this, so I'm not too sure what I'm doing.
That's fine. We have your written brief, so we can review them as well as all of the materials.
Okay, thank you. It might be a little disarrayed. It was my third time redoing it, so I think the middle part may be a little confusing because they're not numbered correctly.
Okay, thank you. All right, Attorney DeRosa, you have 2 minutes.
Okay, yes, Your Honor, I have 2 minutes. Financial affidavit, Your Honor, I want to report that we went back to court on this matter, and I think she just referred to a motion for modification. That was after this what's before the court, but my client has filed a financial affidavit because I prosecuted another motion for modification, and just so the court's aware, it was denied with a very summary decision.
But prior to this, the ruling.
No, after.
Right. Prior to the ruling on appeal, your client had not submitted one since trial, correct?
Your Honor, I think that's correct. I'm not necessarily, the record's the record. I'll defer to the record, but I don't believe there was. And there was, and the other thing is to address Judge DiPatima's comment. My client was not at the 1/13/2020 re-argument hearing. He had won the case, essentially. There was a re-argument on service, and then the decision came out. My client never had the opportunity to contest the underlying facts of the case. It was basically a one-sided view. It was ruled in his favor initially for the reasons set forth in the original decision. After reconsideration, there was just a whole ruling on the entire case. And so my client was not aware. Yes, Your Honor.
Sorry.
There you go.
Was there testimony in the January hearing?
Your Honor, it was legal argument.
Okay.
It was legal argument, Your Honor. It was the only testimony that took place is the December 5th proceeding with Miss Sims, and she testified, and with her lawyer at the time, Mr. Richardson, examining her, and there was nobody to cross-examine her. So the hearing was, 20 minutes or 30 minutes, and the court took it under advisement. And there were 3 exhibits. I've included them all, I think, in the appendix of my brief.
Mr. Zucco did not have counsel appear on December 5th.
Correct. December 5th is when he asked for an extension, and it was denied. And this was what she just referred to. He had 2 opportunities. It was denied. So they proceeded without him. Then he hires Mr. Lewis. The decision comes out after Mr. Lewis is retained that he was in his favor. So Mr. Lewis was in the position of defending a win, not prosecuting a re-argument. Then what happened was, to be clear, Mr. Lewis then filed a motion to re-argue and reconsider, and that was denied. And from that decision, we took the notice of appeal. And it's a rather strange history because the decision to deny the re-argument didn't issue till November, even though the decision was issued in August. That was just, I'll chalk that up to the pandemic. You know, there were just craziness.
All
And
right,
so that's
Attorney DeRosa, you're out of time.
fair enough.
Thank you both for participating in this argument remotely, and we will take the matter under advisement, and the court stands in recess.
Thank you, Your Honor.
Thank you.
Thank
Thank
you.
you.